Minutes to an hour. If you ask questions, please keep them short, because as you're talking, it's dead air going out to the branches that are getting this webcast, and then the question has to be repeated so everyone can understand what question was asked. So again, questions should be relatively short, and they'll be repeated so that the branches can get them. If the branches have any questions, if you know somebody's here, text them, and they'll take care of your questions. I know it's difficult to get questions asked from the branches. Eugene Davidovich from Americans for Safe Access is going to be introducing the two speakers. This organization is primarily one of the organizations that the subject matter expert in defending medical marijuana cases. They'll tell you how to do that and where the resources are. Thank you.
Hello, everyone, and thank you very much for joining us today. My name is Eugene Davidovich. I'm the San Diego Area Liaison for Americans for Safe Access, as well as the San Diego Chapter Coordinator. Americans for Safe Access is the nation's largest organization of patients, concerned citizens, medical professionals, and scientists promoting safe and legal access to medical marijuana for therapeutic use and research. We provide legal training and medical information to patients, attorneys, health and medical professionals, and policymakers throughout the United States. We also organize media support for cases, raid response to law enforcement raids, and capacity building for advocates. Our successful lobbying and media legal campaigns have resulted in important court precedent, new sentencing standards, and more compassionate community guidelines. And for the legal portion of the training today, I'd like to introduce two expert attorneys here in San Diego in dealing with these cases, Lance Rogers and Bahar Ansari, who have successfully defended several medical marijuana cases here in San Diego. Thank you.
Thank you. Again, I just want to thank the County of San Diego, County Public Defender's Office for offering us this opportunity here today. I see a lot of folks who I respect and admire in the audience here, and I'm sure there are other folks that I can't see in the different satellite offices. And I want to thank you all for coming here today. Again, my name is Lance Rogers. I'm a criminal defense attorney, and I've had the fortune of working on behalf of a couple of medical cannabis patients in their cases. I just wanted to do a brief introduction very briefly, and just by way of show of hands, has anybody in the room ever encountered a medical cannabis situation? By that I mean, has anybody ever defended a medical marijuana case? Okay, so for those out there, I'm seeing probably 65% of the hands in the audience. Has anybody in a different capacity ever been approached by, said, what is this medical collective concept? Show of hands, anybody? So again, I'm listening about half the audience. So today's training is going to be very quick. It's going to move along very quickly. I welcome everybody to look at the materials that have been provided to you as well, because there's absolutely no way that we can cover everything in 50 minutes. We're going to give you as much as we possibly can, open it up 10 minutes for questions at the end. I think that'll be most productive because, again, you guys are all sophisticated, experienced litigators, and we won't talk down to you. Marijuana is illegal under federal law. That's where we start, okay? There is an exception in the state of California under the medical marijuana laws that have been around for 14 years. Again, some judges consider this immunity, but at the end of the day, I think it comes down to, it is lawful in the state of California to use, possess, and cultivate marijuana for medical purposes. That's where we start. I know that the term marijuana is a loaded word that comes from a long history, but for 14 years in the state of California, the use of medical cannabis for medical purposes has been legal. I just want to put that out there. In our own county, throughout the state of California, there is a difference of interpretation, though, about what activities are provided immunity. And that difference of interpretation leads us to very different cases all the time. Again, medical marijuana laws cover not just what we're here for today, criminal defense, but the constitutional issues, employment law issues, civil litigation issues, corporate issues, the whole gamut. We're going to focus on criminal defense, but we'll just put that out there that it is a controversial topic and one that is subject to different interpretations. And I don't think it's inaccurate to say that our local district attorney's office has a different interpretation of the law than other attorneys and perhaps even other district attorney's office. with that, want to jump in. I thought I'd talk briefly about a case that I handled. This is People v. Jovan Jackson from 2008-2009. It was a case that went to trial, and Mr. Jackson was acquitted by a jury. This, just to give you a very brief background, was a storefront collective that had somewhere between 1,500 and 1,600 members. It was raided by Narcotics Task Force, and the case went to trial in November and December of 2009, and he was acquitted on December 15, 2009 of all felony marijuana charges. He was charged with a separate offense and was found guilty before a jury in about 3 months ago. That case is currently being appealed. Again, Bahar Ansari has handled cases as well. You want to do a quick introduction and we'll launch into it?
Yes. Hi everyone, my name is Bahar Ansari. And I feel very privileged to be here speaking to you all today. Just a little brief background about who I am. I moved to San Diego about 1.5 years ago and started my own practice and criminal defense practice, and the majority of my cases are medical marijuana cases. Of the 3 medical marijuana cases that have gone to trial in San Diego County, I handled one of them. I believe it was the second one. In that case, my client, by the way, I second chaired that trial, so a lot of the credit goes to my co-counsel, Michael McCabe. The client was charged with possession with intent to sell, sales of marijuana, and possession of concentrated cannabis. He was a qualified patient. He was operating a collective. It was what we refer to as an informal collective. That is, it wasn't incorporated under the laws of the state of California. It was merely a group of patients getting together and growing marijuana collectively for their own medical purposes, which is what the Compassionate Use Act, the Medical Marijuana Program Act, which we'll talk about later, was intended to allow patients to do. And in that case, there was not a storefront. It was a delivery system. And we believe the case spanned a couple of weeks. It was about 2 weeks, and the jury returned a not guilty verdict in about 3 hours. And as we go through some of the materials, we'll talk about, Lance and I both will talk about some of the issues that come up and the arguments that the prosecution makes regularly, trying to exclude the medical marijuana defense and arguing particularly that sales of marijuana are not legal, which is, as we'll talk about later, are directly contrary to the language of the Medical Marijuana Program Act, as well as all appellate cases on point and the Attorney General's guidelines. So with that, we'll just go ahead and get on with the PowerPoints. So in 1996, the voters enacted Proposition 215, which is known as the Compassionate Use Act. The Compassionate Use Act, well, first of all, I think it's important to note the purpose of the Act, the stated purpose of the Act, which is set forth in Health and Safety Code 11362.5a, is to ensure that seriously ill Californians have the right to obtain and use marijuana for medical purposes where that medical use is deemed appropriate and has been recommended by a physician who's determined that the person's health would benefit from the use of marijuana. And then it goes on to list a number of actual medical conditions like cancer, anorexia, and AIDS, and it ends with a catch-all phrase, or any other illness for which marijuana provides relief, which is wonderful, which means that it can be used to treat any illness as long as the doctor feels that it can provide relief to the patient.
Just speak up a little bit, they can't hear you back
there.
Hear
from our stage manager. Can you hear us in the back?
Yeah.
You can hear?
Yeah.
Okay. Also, and we'll get into this later, the the use of the word seriously ill in that portion of the statute, the prosecution sometimes tries to go behind the doctor's recommendation and question whether the patient is seriously ill, or that the doctor's recommendation was warranted given the patient's medical conditions. There is a case called People versus Spark, which is in the materials that you were provided, and that case expressly prohibits the prosecution from trying to go behind the doctor's recommendation and get the complete medical records of the patient. All they are entitled to is the actual physician's statement and recommendation recommending the use of marijuana. And then in 2004, the legislature enacted Senate Bill 420, which is known as the Medical Marijuana Program Act. Among other things, the MMPA allows patients to associate for the purpose of collectively or cooperatively cultivating marijuana for their personal use. It sets forth limits on the quantities that a patient may possess, both of dried marijuana and plants, and later we'll get into what happened to that portion of the statute. It was declared unconstitutional. The MMPA also created guidelines and called for the implementation of a county ID program, and it expressly allows for defendants to request the court to confirm that at sentencing, or even after sentencing, to request that the court permit them to use their medicine while they're on probation, while they're out on bail, or while they're on parole. It also prohibits officers from refusing to accept a valid county-issued ID card when they're presented with it by the patient at a traffic stop or any other kind of stop. Moving on to slide 5.
This one?
Yeah, I think it's the one before. Slide 5. See Ray?
This one?
Yes. Okay. The primary provision of the Compassionate Use Act is Section 11362.5 of the Health and Safety Code, and that provides that Section 11357 relating to possession and 11358 relating to cultivation of marijuana shall not apply to a patient or a patient's primary caregiver who possesses or cultivates marijuana for the personal medical purposes of the patient upon written or oral recommendation or approval of a physician. So basically what that does is it provides a limited immunity or exemption from the laws making it illegal to possess or cultivate marijuana to patients who possess a valid recommendation or county-issued ID card. And that section only applies to possession and cultivation. Next slide. The MMPA, the main provision of that, which provides a defense for clients who are charged where there is a collective or cooperative or a storefront dispensary situation. There's basically 3 elements to the defense. The defendant has to be a qualified patient, a person with a valid identification card, or the designated primary caregiver of a person who's a qualified patient or a person with a valid ID card. The patients must associate within the state of California in order collectively or cooperatively to cultivate medical marijuana for medical purposes. As long as those elements are met, the defendant shall not solely on the basis of that fact be subject to criminal sanctions under and then it goes on to list a number of code sections, and those code sections refer to possession, cultivation, possession for sale, transporting, selling, importing, or giving away marijuana, maintaining a location for unlawfully selling, giving away, or using controlled substances, managing a location for the storage, distribution of any controlled substance for sale, and the laws declaring the use of property for these purposes a nuisance.
I might jump in there real quick too. Again, the subtle distinction against CUA, Compassionate Use Act, 1996, MMPA, Medical Marijuana Program Act, 2003. If you notice, CUA covers simple possession, cultivation, small amounts. MMPA, 2003, covers your felonies. So it's an important distinction. And when you look at the CalPrims on it, it's undecided yet whether it applies to felonies. We're hoping that will someday be decided. But the statutory authority is 11362.775 for felonies. Sorry.
Thanks, Lawrence.
Yep.
Okay. The group farm fallacy. This is an argument that the district attorney's office makes every time, and that is that in order to comply with the statute, with the Medical Marijuana Program Act, every single member of the collective has to actually participate in growing the marijuana. That is, they have to actually do something like water the plants, trim the plants. They actually have to contribute labor. Obviously, that is absurd, because the purpose for this statute is that some patients are too sick to be able to do anything for themselves, let alone cultivate marijuana, which involves heavy lifting and a lot of physical labor. Also, there's people obviously who don't have the time or the skill to cultivate marijuana. So what the Medical Marijuana Program Act does is it allows patients to join together so that they can do so collaboratively, and each can contribute in whatever way he or she can.
I want to jump in here too and make sure that Bahar nailed it, but I want to make sure that it's strong language, fallacy, absurd. I take credit for this because I wrote this, so although Bahar did a great job, I just don't want anybody to say, oh, well, that was Bahar's strong language, absurd. I do think it's absurd. I agree with everything she just said, but the concept, this is a very critical distinction at this point, and this is very up for interpretation. There are collectives in other parts of the states in which exactly this group farm type scenario does occur. In Northern California, for example, patients come together and all toil the fields together. There are regulations being contemplated throughout the state, as well as in our own city and our county, that are being developed right now, that try and determine, well, what is it that 11362.775 intends people to do exactly. The concept of a storefront is, up for interpretation, and it's controversial. Now, what it comes down to is, does 775 say that one person can cultivate and other people can distribute at a different location, or does it mean that everybody has to cultivate? And that's kind of where this comes from. Fallacy has the same letter as farm. I thought it sounded nice. Maybe it's the group farm discussion. But so I jump on that grenade for you, Bahar.
Thank you, Ryan.
No.
Okay, and there is actually case law on point, and also the 2008 Attorney General guidelines that directly contradict this fallacious argument. The two cases are, and these are in the materials that you all have access to. I believe you were emailed. One case is People versus Ursizinu. I always have trouble pronouncing that one. And the other case is County of Butte versus Superior Court. Moving on to the next slide. the Attorney General guidelines, which were issued in 2008. They, of course, do not have the force and effect of law, but courts follow them as if they do. So far, I have not encountered a judge who does not treat them as if they were law. Also, I wanted to note that in the trial that I mentioned earlier, we actually used the language from the Attorney General guidelines for our jury instructions. In that case, the District Attorney's Office, of course, argued that sales were not legal. The judge determined that they were wrong because there is case law that point directly to the contrary. And then there's language in the Attorney General guidelines that we'll talk about in a minute that makes clear that, at least according to the Attorney General, that sales are permissible. Yes, sir.
Is there any sense that Kamala Harris, the Attorney General, is going to change or modify these?
These are written by now Governor Jerry Brown.
We have to repeat the question.
Yeah. For the question again was: is there any indication or smoke signals that new Attorney General? Again, it's my understanding it's still up for grabs. They're still trying to work. Maybe not. Maybe she's been confirmed. Excuse me. I thought he was challenging. Okay, good. I'm seeing nods in the head, so good.
Yeah.
We like Ms. Harris because she has not made the prosecution and investigation of ostensibly medical marijuana patients and collectives a high priority. So who knows? She's obviously head law enforcement for the state of California, but I haven't seen anything that they're going to repeal or modify these guidelines. But it is a good question.
Okay, moving on to slide 10, distribution and sales. Okay, so first of all, the language of section 11362.775, as I mentioned before, expressly includes sale of marijuana as one of the violations that a patient or collective is exempt from, as long as they comply with the law in every other manner. In addition to the express language, I already mentioned that the case of Ursiziyanu and County of Butte, both of those cases held, or if it wasn't an actual holding, I mean, it may have been dicta, I can't remember, but there is language in both of those opinions that sales are legal, and I know in the case of Ursiziyanu, the court expressly referred to the 11362.775 and said, the argument makes no sense because it expressly allows sales. And then it also referred to the Attorney General guidelines, which also expressly allow sales. According to the Attorney General guidelines, a dispensing collective may credit its members for marijuana they provide to the collective, which it may then allocate to other members. Members also may reimburse the collective for marijuana that has been allocated to them. Any monetary reimbursement that members provide to the collective should only be an amount necessary to cover overhead costs and reasonable operating expenses. So overhead costs are, that's obvious what that means. The reasonable operating expenses include salaries of the people that work at the collective, and just compensation for time and effort in cultivating marijuana and distributing it to members, and any other costs or labors associated with the collective. Moving on to the next slide, the guidelines further provide that a collective should be an organization that merely facilitates the collaborative efforts of patient members, including the allocation of costs and revenues. The collective should not purchase marijuana or sell to non-members. It should only provide a means for facilitating or coordinating transactions between members. It has to be a closed circuit of members. A collective also may not distribute marijuana to any person who is not a member in good standing of the collective. And we'll get into what it means to be a member in just a minute. So the next slide, collectives and cooperatives. They are defined as an association of individuals united voluntarily to meet a common goal. I know in the trial that I was mentioning earlier, I think we looked in the jury instructions. At first, we looked at just using the dictionary definition. I believe the Attorney General guidelines actually uses the dictionary definition, and I think that's what we ended up using, which is the definition I just read. The collective or co-op generally owned and operated by members for their mutual benefit. Some members contribute with labor or resources, and some contribute only financially. And again, there is case law supporting that is absolutely fine.
Can I jump in one thing too?
Of course.
An important element of this that I think has not gotten into the slides, but I think it is important, is that I want to say 11362 it's actually it's either 765 or 775 says no individual can make a profit from sale of marijuana. So that is an important aspect to consider. What attorneys have interpreted that to mean is that analogously no collective or cooperative could also make a profit. There are some states, Colorado for example, where a collective can make a profit, but in the state of California, a collective cannot make a profit off of the facilitation or the distribution of medical cannabis.
Even though they have to pay sales tax, which is interesting, I think. Okay, so also I just wanted to point out, and I think I mentioned this before, that a collective does not have to be formally organized, in that it doesn't have to actually incorporate as a legal entity. It can simply be two or more patients who get together and decide they want to grow marijuana together, and they collaborate and put together the resources and grow, and as long as they do so for their own personal medical use, then they're a collective and they're following the statute. The next slide, dealing with membership. Membership, it became an issue in the trial that I've been referring to. The district attorney attempted to make a big deal about the fact that in that case there were no formal membership written agreements. At storefront dispensaries, there's a lot of paperwork. The patients that come in have to fill out a form to become a member, and there's a record kept of that. In informal collectives, people generally don't do that, and in the case that I defended, the defendant did not do that, and that turned out to be fine. And during closing arguments, lead counsel analogized membership in a collective to membership in a church, which really went over well with the jury, I think. So,
in my case, we analogize the difference between going to Ralph's to get your organic tomatoes or join People's Market in OB. Subtle distinction, but people kind of get the idea of joining a collective.
Okay, and as far as membership, only qualified patients or persons with ID cards, which is basically the same thing. The statute makes a distinction that people between qualified patients, who are people who merely have a recommendation from their doctor, and persons with ID cards, who then they take the recommendation and they go and get a county-issued ID card. But basically they're one and the same. They're medical marijuana patients that validly can possess and cultivate marijuana. and as well as designated primary caregivers can join. Collective or cooperative association to cultivate is necessary. And we can move on to slide 14.
Is this one I jump in?
If you would like, I was going to do this, but go ahead.
No, go ahead.
Yeah, go ahead.
We drew straws before. It's like, are we going on 3 or after 3? You want to take it with me?
All right, I'll do it for you.
Thank you.
You're welcome. Okay, medical marijuana may be, and this is actually directly from the Attorney General guidelines. Medical marijuana may be provided free to qualified patients and primary caregivers who are members of the collective, provided in exchange for services rendered to the entity, allocated based on fees that are reasonably calculated to cover overhead costs and operating expenses, or any combination of the above. So it's number 3, allocated based on fees that are reasonably calculated to cover overhead costs and operating expenses, that makes clear that sales within a collective are lawful. And that's it. Lance will continue.
All right, what's the next slide? Okay, so preliminary considerations. These are sort of general topics that I'll try and move through as quickly as possible. Searches. As I say a lot, the medical marijuana laws do not provide a defense to arrest, search, and seizure or prosecution. It's only a defense to conviction, really. But you can certainly argue a 1538.5 motion if somebody has a recommendation or a county-issued ID card. In fact, the county-issued ID card, and just so everybody's aware, you can go to a doctor and get written recommendation. You then can take that written recommendation and go to the County Department of Public Health, pay $166, and get a standardized county-issued ID card, which is issued by the state of California. If you have that card, and you're stopped, and your amounts are reasonable, and there's no other indicia of sales, then it is a get-out-of-arrest-free card. It says that you shall be let go. So if somebody encounters that type of situation with the county-issued ID card, reasonable amounts, nothing else, 1538. Arrests, again, there's nothing we can do about arrests. But again, it is not a defense to arrest. Motions for return of property, and I'm happy to talk directly to this group on this issue because I understand that you're somewhat limited in filing a return of property motion. If the public defender's office can take it on, again, what property we're talking about here? We're talking about medical cannabis, and yes, believe it or not, you can request the court to force the return of medical cannabis from SDPD, SD sheriffs, CHP. So. I know you probably get that request from some of your clients, and you say, "Are you nuts? We can't do that." Yes, you can. We do it all the time. If you need assistance with that, or the other thing you can do is you can direct the defendant to Americans for Safe Access in California. There's a standard template that somebody can file on their own to get the ball rolling. Determination of factual innocence. There was a recent case on this particular issue. You guys probably know that this is really difficult to achieve, but I can imagine a scenario, possibly the arrest, reasonable amounts, county-issued ID card, where a judge may grant a motion for determination of factual innocence. Next slide. Okay, 995 motion. You can get a lot of traction here. Depending on your facts, of course. Some possible issues that come up, and these are in the materials, are a Chacos situation. Chacos is a case where defense counsel said, the investigating officer, the expert who talked about that this marijuana was possessed for sale as opposed to simple possession, did not have expertise in medical marijuana or prescription drugs. This officer was a beat cop, dealing with always illegal substances, rather than did not have expertise in, sometimes illegal substances, if that makes any sense. And I think Chacos is a good issue for 995 motion. Additionally, I think you make the same arguments that you would at prelim that this is a lawful activity, and the Maurer case and the Konow case are good authority for a 995 motion. An informal request to dismiss in the furtherance of justice. Bahar has had a request granted, no, not granted, but in any event, entertained, and a judge did grant a 1385 request.
Actually,
oh, it wasn't. I'm sorry.
Yeah, actually, it was a 995 motion.
Oh, it was my fault.
Yeah. At the prelim, we put on my client was cultivating collectively with two of his friends who were also patients. Both of his friends testified that they were all growing together, and they were actually all contributing, their labor to the effort, and that they were going to split the yield 3 ways. We had an expert testify as to the yields and dosages, and basically that it was a reasonable amount, which is often the biggest issue. In the end, the judge said that although there does appear to be a lot of evidence and you may very well win at trial, there's a lot of credibility issues here, and it's not for me to decide them. So in the 995 motion, I argued that it is, in fact, the job of the magistrate to decide those credibility issues. There's a handbook, there's a judge's or magistrate's handbook on what they should do at prelims, and it specifically says that they are required to decide credibility issues. So I raised that at the 995 and won the motion, and so the case was dismissed.
And I had a case dismissed in the furtherance of justice by a judge who I won't name by name because I really like him. And this was 2 qualified patients, transportation and possession for sale of a little under or almost, maybe a little over, I don't know, 2 pounds. And that request was, deemed a good request. I'm not sure how to phrase that. Motion to preclude defense under Evidence Code 402. Again, this is the motion to exclude the defense entirely. In the second trial of my client, Jovan Jackson, the judge precluded the defense, and that made it very challenging to litigate the case. And these are one of these interpretations that need to be ironed out. This judge interpreted that when it says collectively and cooperatively, patients may associate to collectively and cooperatively cultivate marijuana. He emphasized cultivate. And so unless you can show sufficient evidence of cultivation and this is again a storefront, then the defense does not apply. As you can imagine, there are tactical problems with presenting that type of information, because members who cultivate essentially have to take the stand and admit to committing obviously a federal offense, and then a state offense as well that would have a defense. And not to get on a soapbox too much, but I do want to just put this out there that when you are advising your clients, you obviously need to be cognizant of their interests, and I get that. But when it relates to medical marijuana, this is an activity that is not always illegal. So if you have a client who is a witness, you obviously have to do your job. But the collective defense, believe it or not, as I just indicated, kind of relies on people testifying to what they did, because if you as a defense attorney are trying to present this collective defense and everybody else has gotten out of Dodge, your client's the one left holding the bag of weed, and he says, well, it's not all mine. Oh, really? Whose is it? Well, it's these guys, and then you have no evidence to put on. So I'm just putting that out there. Motion and limited to exclude reference to trial. The quantities, People v. Kelly is in your materials, January 21st, 2010. Cal Supremes, it says that limits are unconstitutional. We do have local limits. San Diego Municipal Code, I'm sorry, I don't have it in front of me, but says that a patient may possess an amount not to exceed 1 pound or an amount that is reasonably related to their medical needs. So again, that kind of anticipated the Kelly decision. Obviously, it's not a green light to always possess a pound. It's not to exceed. That's the maximum. What it boils down to is what is an amount that is reasonably related to that individual patient's medical illness or injury. Those are arguments for you to make. Those are arguments that can be assisted by an expert. There are experts that are out there that you can access through Safe Access, Americans for Safe Access as well. That's dosages and things like that. What's the next slide? Okay, elements at trial. Who knows right now? The defense is still coming out. I mean, do you have an idea about what the elements are? So in my trial, it's a special jury instruction. We created it. In Bahar's, same thing. Ours differed a little bit. So it's a defense that you have to create and probably will continue to be created until the commission of judges just tells us this is a defense and here are the elements. But okay, we'll move on. Yeah. Persons included qualified patients and primary caregivers. Qualified patients are people with a written or oral recommendation. A county card is preferable because it's standardized license. Law enforcement likes that. Just so you know, recs expire. A lot of times, again, it needs to be a current recommendation for the use of medical cannabis. Illnesses included, 11362.5, I believe, has a list of the explicit illnesses and injuries that they considered. Subsection D or E says, or any other illness or injury for which marijuana may provide relief. So that's your catch-all. And we could, I'm sure, entertain wonderful conversations about that outside after this talk. Again, it need not be in writing. It does not need to come from the patient's primary doctor, just a licensed physician or osteopath. I'm not going to comment on 3. Okay, there are expert witnesses that will talk to you about dosages. Again, medical cannabis is a Schedule I drug. Again, it is illegal all of the time under federal law. Again, the FDA is the regulatory agency that issues standards about dosages, and so there's a vacuum of information about proper dosages. So into that void step, various cannabis experts that you can locate throughout the state, they will come in and tell you that a person suffering from stage 4 colon cancer may prefer to ingest cannabis through an edible form, and because he does that, he needs 1 pound a week. And when he was stopped with 4 pounds, that's because he was just procuring his medicine for the next month. And those types of things. Yields, if it's a cultivation case, similar type of discussions. How much does one plant yield? Obviously, there's a different. A lot of times the Narcotics Task Force, which is again a joint, everybody here knows this, but it's a joint task force of federal and local law enforcement who are doing their job, will come in and say a plant is a plant is a plant. So if we're talking a 1-inch plant, that's the same as a behemoth that's got pineapples growing from it. But I think that would have a different effect on a jury, and especially when you're changing or calculating plants to amounts for possession purposes. Court support. Again, what this means is this is a case, and I'm not going to get on a soapbox, but I am going to get on a soapbox real quick. I interned with the Public Defender's Office, and I had a great opportunity of doing that. And during that time, I learned that a lot of the people that I talked to had stories to tell, but at the end of the day, a lot of them, were guilty of something. A lot of times they weren't guilty of everything that they were charged. Most of the time they weren't guilty of everything that was charged. But I want to just put out there that you may, in your career and your experience looking at medical marijuana cases find an individual who's not guilty of anything, and this is an area that that people watch closely. The community will support these individuals to get through this. Obviously, it's not your role as an attorney to reach out to those people, but it may be something worth considering as your role as a counselor. So that's out there. These are other defenses. I think it might be more productive to jump into question and answer. All of the cases are listed in the material. If you agree, Bahar.
Yeah, I do.
Okay. All right.
I'm not going to have time to get through.
Yeah. So first of all, questions that are out there. And if there are no questions, we can go into cases, I guess. Yes.
I just have one question. Now, if someone's driving under the influence of marijuana, what's the cutoff level in the anagram?
Oh man, that's a good question. Have you looked into this? The question again is, what is the cutoff level for the presence of THC in the bloodstream for purposes of the A count? All the PDs are going to look at me right now. For DUI, a DUI charge. Have you looked into this? I've looked into it, but
I have looked into it, although I cannot remember. But my husband is a public defender in Kentucky, and before that he worked for a marijuana policy project, and he knows everything there is to know about this issue. So if you'd like afterwards, I can get your email and email you the information.
It's a great question, and in my experience, and obviously everybody in the room here has a lot more experience with misdemeanor DUIs than I do. But recently, it has been unlikely that a straight marijuana DUI gets filed. I might have things thrown at me for that, but a lot of DUIs obviously are a combination of alcohol and marijuana. If it's a pure marijuana offense, there are studies within the last 2 years out of Europe that distinguish between the presence of THC in the bloodstream that may have been there, that may be from habitual use. And excuse me, that I don't want to use that as a negative term, but if somebody's a medical marijuana patient, there's going to be the presence of THC in their system because of that. So it's kind of the margin of error type thing that everybody works with on DUIs. I think 10, and again, remember there are three things that so you're only looking at the active THC levels, and I think 0.10 for some reason stands in my mind, but everybody here has much more experience than I do. But there are studies out there that I think you can pull in to talk about the presence of THC that's there always for a patient.
Yeah, your jury instructions that you guys crafted for your trial, are they in the materials, and if not, can you post them?
Yes. The question again was, are the jury the jury instructions that we created for our trials in the materials? I think the answer is no, but it will be shortly available to everybody, and maybe even available on the Americans for Safe Access website.
Yes.
Okay.
Just from the alcohol office, can you please talk about the primary caregiver?
Yeah, okay. So what is a primary caregiver? That's a question from the El Cajon office. Thank you, El Cajon office. Say hello to everybody there for me. Via page. Primary caregiver, it's important to look at the Mensch case. It's in the Attorney General guidelines. It should be in your materials. A primary caregiver is somebody who cares for the health, safety, and welfare, that might not be the exact phrase, of a patient. It's not a primary caregiver agreement. I can't just sign an agreement to Bahar that she is my primary caregiver, and that comes up a lot. But it is somebody who is providing other critical services to a patient, as well as medical cannabis. That makes sense.
Just to add,
Yeah.
The exact language of the statute and in the Mensch decision is that the primary care, there's two elements. One is that the primary caregiver must have been designated as such by the patient, and two, the primary caregiver must have consistently assumed responsibility for the housing, health, or safety of the patient. So in practical terms, consistently assuming for health, safety, or housing, taking the patient to doctor's appointments on a regular basis would qualify maybe doing errands for the patient on a regular basis, maybe cooking, or allowing the patient to live at the primary caregiver's house.
I got to tell you though, that's so funny that came from El Cajon because El Cajon, a judge in El Cajon recently had a real tough time with this, and we did not succeed, showing that somebody who drove a patient to doctor's appointments and cared for her children qualified as a primary caregiver. Yeah.
Can you talk about the relationship or the difference between profit for individuals and salary to get out of overhead?
Boy, that's a difficult question. The difference between profit to an individual or profit to the organization or overhead.
Because you're allowed to take salary from the collective as part of the overhead, is that correct? I thought I heard that.
Bahar said that.
Yeah.
Operating expenses.
Reasonable operating expenses. Right.
Yeah, so if an employee of the collective was taking a weekly salary, how do you distinguish that from profit?
From profit.
Again, the question for everybody out there is, how do you distinguish an employee of a collective taking a salary from that being a prohibited profit under 11362765 subsection A?
That is a really good question. I have so far I have not been faced with that issue. So anything I say now is just my own theories and thoughts. But I would say that just a reasonable salary for somebody's work and time is distinguished from profit, which I don't know what the dictionary definition of profit is, but I assume that it's something to the effect of money earned, over and above the costs of operating a business, which I think the costs of operating a business would include salaries for employees.
Can you direct us to studies that validate marijuana as an analgesic?
So the question is, we direct to research that validate studies of marijuana as an analgesic? Yes, and Mr. Davidovich is going to chime in from Americans for Safe Access.
Yes, since this isn't the legal portion of the part, I'd like to address that for any kind of studies. We have a medical section on our website that contains literally hundreds of links to studies of all sorts of different effectiveness of medical cannabis that has been found. As most recently here in San Diego, the UCSD has issued a study in February where there was, I think, 4 different studies conducted, and multiple sclerosis was one of the issues discussed in those studies. So you can take a look at our website, safeaccesssd.org, or americansforsafeaccess.org. That's on there. It has a medical section. All those studies are there.
Thank you.
Yeah.
I had a case where they got the medical marijuana card after their conviction, but then they got violated for the probation because they had marijuana, yet they had gone out and got the medical marijuana card at that point, leaving the county card, and Judge Schmowski still violated.
Yeah. So again, the comment was that someone had a case recently where an individual was on probation and a judge violated them for, I'm assuming, use or of possession of a controlled substance, marijuana. So again, Bahar talked a little bit about how that is specifically addressed in the Health and Safety Code. The Tiliku case, Tilek. There we go. Wow, excellent. 2003 also addresses that particular issue. Yeah.
Judge Schmowski has a problem with it, and so if you're faced with that situation, you have to set it for an evidentiary hearing and get it out of the Senate.
Okay.
There's absolutely no reason to try it particularly.
Somebody in the audience was saying that Judge Schmowski has problems with that particular issue, so set it for an evidentiary hearing in a different department.
Most of the judges are reasonable, and he's very reasonable about other things, but this is a pet peeve of his, and so you cannot have that issue litigated before you know.
Yeah.
Can you tell us who your experts are on dosage and yield?
Yeah. The question was, who are our experts or possible experts for dosages and yields?
There's 2 experts that I can refer you to. The foremost expert who testifies all over the country is Christopher Conrad. He's written a number of books and publications. One of them is called Cannabis Yields and Dosages, which is very helpful for an attorney to read, just to understand yields and dosages. And that is available, I don't know the website, but if you Google Cannabis Yields and Dosages, Christopher Conrad, it'll come up and you can print it out in a PDF version. He testified as the expert in the trial that we won, and he was excellent. The other expert that I have used many times and recommend is William J. Britt. He is in Long Beach, and he testifies primarily in Southern California. And he's excellent, and the juries and judges seem to like him.
Any other questions? All right. I want to thank you all again very much for coming out.
Thanks for those in the branches. This was our most well-attended training. Go figure. We have about 60 people in the downtown office, so clearly we're going to have to explore becoming a collective that'll increase our MCLE numbers. So who knows what the future holds for our training program. Thank you very much, and we'll see you in a couple of weeks.